Hello students, in the previous session we discussed about judicial control or administrative discretion of administrative authorities and few of the grounds related to it. In this session let us see few more grounds related to it. Second ground of judicial review is using discretionary power for improper purpose. If a statute confers power for one purpose, its use for different purpose will not be regarded as a valid exercise of the powers and the same may be quashed. The cases of exercise of discretionary power for improper purposes have increased in modern times because conferment of broad discretionary power has become usual tendency. The orders based on improper purpose were quashed first in the cases concerning the exercise of powers of compulsory acquisition in England. So, where the power is exercised for a purpose different from that specified in the statute, the court will declare the exercise of the power as ultra vires. Where the land is acquired by municipal corporation ostensibly for a public purpose, but in fact to enable another body to acquire it through the medium of corporation for some other purpose, the acquisition order would be quashed by the court. Similarly, where municipal corporation refused to approve the construction of buildings with a view to pressurizing the petitioner to provide drainage for the adjoining building and where the construction scheme of the petitioner does not contravene. Improper purpose is broader than mala fides, for whereas the latter denotes a personal spite or malice, the former may have no such element. The action of an authority may be motivated by some public interest, but it may be different from what is contemplated by the statute under which the action has been taken. Here it is not so much relevant to assess whether the authority is acting in good faith or bad faith. What is relevant is to assess whether the purpose in view is one sanctioned by the statute which confers power on the authority concerned. In a few cases on preventive detention, the Supreme Court has held that the power of preventive detention cannot be used as a convenient substitute for prosecuting a person in a criminal court. In Srilal vs. State of West Bengal, a preventive detention order was issued against a person mainly on the ground that he had stolen railway property. He had documents in his possession to prove his bona fide and to prove that he had purchased the goods in the open market. A criminal case filed against him was dropped and the mentioned preventive detention was passed in its place. The order was held to be bad by the court. Again, in Alkedas vs. State of West Bengal, the court held that the power of detention could not be used on simple solitary incident of theft of railway property and the proper course to prosecute the person was in a criminal court. The third ground is irrelevant considerations. A discretionary power must be exercised on relevant and not on irrelevant or extraneous considerations. It means that power must be exercised taking into account the considerations mentioned in the statute. If the statute mentions no such considerations, then the power is to be exercised on considerations relevant to the purposes for which it is conferred. If the authority concerned place attention to or takes into account wholly irrelevant or extraneous circumstances, events or matters, then the administrative action is ultra vires and will be quashed. Thus, where an administrative order is issued on formal grounds or considerations which are irrelevant, it will be quashed. The exercise of discretion power should not be influenced by considerations that cannot be lawfully taken into account. The determination of the considerations which are relevant and those which are irrelevant is matter of inference from general terms of the statute. The decision of the House of Lords in Padfield vs. Minister of Agriculture lays down the parameters of judicial control of administrative discretion in England. In this case, under the statutory milk marketing scheme, the prices paid to milk producers in different areas are fixed by the milk marketing board, which consist of representatives of the producers. The producers near the area of London complained that though they were in proximity of the London market, yet the price paid did not reflect the higher value of their milk, and requested the minister to refer the matter to the statutory committee for complaints. To direct or not to direct a complaint to the committee was the sole discretion of the minister. The minister, in excess of his unfettered discretion, refused to direct the complaint. One of the reasons given by the minister was that minister would be in a difficult political position if, despite the committee acceptance of the complaint, the minister should take no action. The House of Lords held that the minister's reasons were unsatisfactory and his decision was unreasonable. The purpose of the act was that every genuine complaint must be forwarded to the committee, and anything contrary to this would frustrate the purposes. In Rampur Distillery Company Limited versus Company Law Board, the Company Law Board, exercising wide discretion power under section 326 of the Companies Act 1956 in the matter of renewal of managing agency, refused approval for the renewal to the managing agents of the Rampur distillery. The reason given by the board for its action related to the past conduct of the managing agent. The Vivian Bose Enquiry Commission had found these managing agents guilty of gross misconduct during the year 1946-47 in relation to the other companies. The Supreme Court, though it did not find any fault in taking into consideration the past conduct, held the order bad because the board did not take into consideration the present acts, which were very relevant factors in judging suitability. In Brij Mohan Singh versus State of Punjab, the appellant was compulsory retired from service on the basis of service entries of about 20 years, though during that period he had been promoted many times. The court held that entries of only last 10 years were relevant for compulsory retirement. During this period, 2 entries were adverse to the appellant. The court held that reliance on those 2 entries was also not proper and quashed the impugned order, as the same was based on irrelevant considerations. In S.R. Venkatraman versus Union of India, the appellant, a central government officer, was prematurely retired from the service in public interest on attaining the age of 50 years. The appellant contended that the government did not apply its mind to her service record and the order was based on extraneous circumstances. The government considered that there was nothing on record to justify the order. The Supreme Court, quashing the order of the government, held that if a discretionary power has been exercised for an unauthorized purpose, it is generally immaterial whether its repository was acting in good faith or bad faith. The Supreme Court stated that an administrative order based on a reason or facts that do not exist must be held to be ineffected with an abuse of power. The difference between a power exercised for an improper purpose and on irrelevant considerations is often imperceptible. For instance, where land is acquired by an authority ostensibly for itself, but really for another authority, the power may be said to be exercised in one sense for an improper purpose, but in another sense after the authority took into consideration an irrelevant factors, namely acquisition of land for another authority, the consideration for the administrative action being acquisition for itself. With that, let me conclude this session. We will be discussing more about in upcoming sessions. Thank you.